find that the cause of justice would be served by having this by video. The reasons being pretty obvious, but I'll say a couple of them, which are, one, of course, if we waited for the crisis to pass before having proceedings, that could be a long time. Nobody knows when that's going to be. That would result in delay and harm to the interest of justice. If the case were underway, then it would result in us probably blowing past some important deadlines. The alternative, which is calling people in person, is not a good one, again, for reasons that are quite obvious. I cannot in good conscience be compelling people to appear when it would put them in danger. So for all those reasons, I am finding that the interests of justice would be served by a video proceeding here. So, have you consulted with your counsel about conducting this hearing by video?
Yes, I have, Your Honor.
And after consulting with your counsel, do you consent to proceeding by video?
Yes, I do, Your Honor.
Okay, fine. That was just a bit of housekeeping. Let's get underway. This is technically an initial appearance as well as an arraignment, so let me just quickly do the initial appearance aspect of it. Mr. Mindy, you have, by the way, am I saying your name correctly? Mindy?
Yes, you are, Your Honor.
Okay. You and your client, I take it, have received a copy of the indictment, right?
We have received a copy of the indictment. I've reviewed it with Mr. Edwards, and we waive a reading of it in open court.
Okay. I will inform your client of his rights very briefly. I'm sure he's aware of them. First, you have the right to counsel, whether retained or appointed if you cannot afford it. You have the right to apply for reasonable conditions of release or bail, and we will get to that later. If this were just an initial appearance and not an arraignment, you would have the right to a preliminary hearing within a certain period of time. You are advised that you, like everyone, have the right to remain silent, and that any statement made by you to an agent of the government may be and would likely be used against you in evidence. If you are not a U.S. citizen, I don't understand that to be the case, but if you are not a U.S. citizen, you may request that the government notify a consular office of your country, and that may be required by treaty in any event. As I say, this is an initial appearance which has a shelf life of about 10 seconds because we're going to go to arraignment immediately. Now, before we do that, let me just say again, because it's a new world, we are doing this not just by video, but with the presence of many members of the public and the press. And I want to tell you all that you're very welcome. And I'm very pleased to see that as far as possible, we are maintaining some semblance of normality in terms of this being an open and public proceeding. I recognize that that requires a little bit more in the way of bureaucracy than just walking into the courthouse. But on the other hand, you don't have to go through a metal detector either. So there's that. So we will, anyhow, we are very glad to have you here. The same rules of decorum apply, obviously. It's just as if we're sitting in the courtroom. You're observers, not participants, but I know you know that. So, with that, let's go with the arraignment. I want to place on the record that the defendant and his attorney have received a copy of the indictment, and I believe, Mr. Mindy, you've already said that you waived a further reading, correct?
Correct, Your Honor.
Okay. Now, with that, it is a fairly lengthy document. We have an overarching conspiracy count to defraud the city of Orange of the defendant's honest services as well as money and property by the use of wire transmission, wire fraud. There are 7 counts, substantive counts of wire fraud in connection with 3 programs known as the Saturday Literacy Redevelopment Project and the YWCA Project. There are 2 counts of unlawfully obtaining $5,000 or more in connection with 2 of those programs under 18 U.S.C. 666A1A. There are 3 counts of bribery in connection with a couple of the programs under 666A1B. There is a conspiracy to commit mail and wire fraud in connection with what's called for short the plagiarism scheme, as well as 7 substantive counts of violation of fraud in connection with the same scheme. There is a count under 666A1A of unlawfully obtaining $5,000 or more in connection with what's called the plagiarism scheme. Then there's 2 counts of wire fraud in connection with what's known as the graduate school payment scheme. There is 1 count of 371, conspiracy to defraud the U.S. and the IRS. There's 1 count under 26 U.S.C. 7206 of subscribing to a false tax return. And there are 2 counts under 18 U.S. Code 1014 of false statements concerning a mortgage. Now, that is a number of counts, and so this is going to take a minute, but I will ask whoever's speaking for the government, whether that's you, Mr. Imbert, or Ms. Bass, to tell us what the maximum penalties are for those.
Yes, Your Honor. Good morning. The maximum penalty for count 1.
Okay, Ms. Bass, let me just interrupt you. Let me just interrupt you and ask you to maybe get a little closer to your microphone or something, because you're quite soft.
How's that, Your Honor?
Much better, thanks.
Okay. Count 1, charging conspiracy of wire fraud in violation of 18 United States Code Section 1349, carries a maximum penalty of 20 years in prison and not more than 3 years supervised release, a violation of which would result in an additional 2 years in prison. The maximum fine is of $250,000 or the loss or gain associated with the offense. Counts 2 through 8, 18 through 19, and 23 to 24, charging wire fraud in violation of 18 United States Section 1343, carry a maximum penalty of, per count, of 20 years in prison, to be followed by not more than 3 years of supervised release, a violation of which would result in an additional 2 years in prison, and a maximum fine of the greater of $250,000 or the loss or gain associated with the offense. Counts 9, 10, and 21, charging theft from a federally funded local organization and government in violation of 18 United States Code Section 666A1A, carry a maximum penalty per count of 10 years in prison, to be followed by not more than 3 years supervised release, a violation of which would result in an additional 2 years of prison. The maximum fine is the greater of $250,000 or the loss or gain associated with the offense. Counts 11 through 13, charging bribery in connection with the business of a federally funded local organization and government in violation of 18 United States Code Section 666A1B, carry a maximum penalty per count of 2 years in prison, to be followed by not more than 3 years of supervised release, a violation of which could result in an additional 2 years in prison, and a maximum fine of the greater of $250,000 or the loss or gain associated with the offense. Count 14, charging commit mail and wire fraud, in violation of 18 United States Code Section 1349, carries a maximum penalty of 20 years in prison, to be followed by not more than 3 years of supervised release, a violation of which would result in an additional 2 years in prison, and a maximum fine of the greater of $250,000 or the loss or gain associated with the offense. Counts 20 to 21, charging mail fraud in violation of 18 United States Section 1341, carry a maximum penalty per count of 20 years in prison, followed by not more than 3 years of supervised release, violation of which could result in an additional 2 years of prison, and a maximum fine of the greater of $250,000 or the loss or gain associated with the offense. Count 25, charging conspiracy to defraud the United States Internal Revenue Service in violation of 18 United States Code Section 371, carry carries a maximum penalty of 5 years in prison, to be followed by not more than 3 years of supervised release, a violation of which could result in an additional 2 years in prison, and a fine of the greater of $250,000 or the loss or gain associated with the offense. Count 26, charging subscribing to a false federal tax return in violation of 26 United States Code Section 72061, carries a maximum penalty of 3 years in prison, to be followed by not more than 1 year of supervised release, a violation of which could result in an additional 1 year in prison, and a fine equal to the greater of $250,000 or the loss or gain associated with the offense. Counts 27 and 28, charging false statements concerning a mortgage in violation of 18 United States Code Section 1014, carry a maximum penalty per count of 30 years, to be followed by not more than 5 years of supervised release, a violation of which could result in additional 3 years of prison, and a maximum potential fine of $1 million.
All right. I want to make it clear, that was a statement of the maximum penalties. That is, these are not penalties being imposed. This is the theoretical maximum a person could get for each one of these offenses. It is advisable, though not strictly required by the rule, I guess, to just get that on the record at the beginning of the case. But of course, these are accusations only. It's an indictment only. We're nowhere near sentencing or even in adjudication of the charges. So, but it is something a person should know going in. All right. With that, I have already advised the defendant as to his rights to an attorney, whether retained or appointed, to apply for reasonable conditions of release, and that any statements he makes may be used against him. So with that, I will ask you, Mr. Mindy, what plea would you like to have entered on behalf of your client?
Your Honor, at this time, on behalf of Willis Edwards, he enters a plea of not guilty to all the charges.
All right. A plea of not guilty will be entered to all of the charges in the indictment. Let's briefly address the subject of bail or conditions of release. I'm not seeing a lot of flight risk here, but let me hear the government on that.
Yes, Your Honor, but before we do, if I could briefly administer a Padilla warning to Mr. Edwards.
I'm sorry?
If I could briefly administer the Padilla warning to Mr. Edwards before we address bail.
Okay.
I'd just like to advise Mr. Edwards that if you are not a citizen of the United States, conviction of the charged offenses will likely result in you being subject to immigration proceedings and removal from the United States. Thank you, Your Honor.
Okay, that's in the nature of sort of an addendum to the maximum penalties, I guess. So that's fine. A person should know that. Do you have any reason to think that there is such a component to this case?
I don't, Your Honor, but in an abundance of caution, we administer the Padilla warning just in case Mr. Edwards, has a citizenship issue we're not aware of.
Sure. These are things that can happen if you do have an immigration issue. You may not, but be advised. So with that, a plea of not guilty will be entered on the defendant's behalf to all of the charges in the indictment. Now, as I said, let's proceed to the issue of bail or conditions of release. What is the government's position on that?
The government agrees with the terms proposed by pretrial services, and the parties actually agree to those terms with the following exceptions. The parties both agree to modify term number 3, which restricts travel to New Jersey and Georgia, to be modified to include North Carolina, where Mr. Edwards' child is in school, and also to include South Carolina for the purposes of traveling from Georgia to North Carolina.
Going through South Carolina, you mean from Georgia?
Correct.
Oh, yeah, sure. Yeah. All right, that makes sense. Everything else is, the suggested conditions are otherwise fine with the government?
They're fine with the government, Your Honor, yes.
Okay, let me move over to you, Mr. Mindy. Is that your understanding as well?
Judge, it's my understanding correct as to what Ms. Fayes said about the travel restrictions. There are two other points that we wish to bring to your Honor's attention. You know, we don't see any scenario where Mr. Edwards is considered either a flight risk or a danger to the community or others based on his life to date, the findings by pretrial or anything of that nature, including the nature of these offenses, which, you know, are mostly financial and for, you know, general terms, corruption or white collar offenses, certainly not violent offenses. Towards that end, specifically, condition number 8 that requires Mr. Edwards to surrender and not possess any firearms. You know, he has a Second Amendment right to the firearm, which I understand could be curtailed if there was a reason to believe in this case that it was necessary. However, Mr. Edwards does lawfully possess a firearm in accordance with Georgia law. He uses it for sport, for hunting, and for protection of his home, as he's entitled to do so under the Second Amendment, as he does so consistently with New Jersey law. The pretrial report here says, under 8, recommendation surrender, do not possess any firearms. All firearms in any home in which the defendant resides shall be removed in compliance with New Jersey state law within 24 hours and verification provided to pretrial services. I wonder if that is boilerplate language that found its way in, but Mr. Edwards is, as Your Honor knows, residing in Georgia. And so I would submit that not only does New Jersey state law not apply to him as it would pertain to whether he can have a firearm while residing in Georgia, but there's no corresponding Georgia law that would require him to turn over the firearm upon charge. And he's not a danger. He has no prior violent charges. There's not any incidents of violent arrests or any prior arrests. So that requirement, Your Honor, we think is just not warranted in this case, and we would ask Your Honor to remove that requirement.